Yeah, I'm audible, sir. I'm Ashish Singh.
Yes, you are audible, please.
Yes, yes. Uh, uh, I'm company secretary and advocate, and I'm insolvency profession. In the field of the IP since 2017. So I've done some assignments, sir. Around 15 assignments I have done, both in the CRP, PIRP, and the liquidation. So today's topic is individual insolvency. So I'm just sharing my slides. So this is visible, sir. Slide.
Yes, it's visible.
Okay. So this topic is individual insolvency and another insolvency resolution process for personal guarantor to corporate debtor. It has a major chunk in this individual insolvency. Agendas or the areas we are going to cover in today's session will be chapter 3rd, individual insolvency process for the personal guarantor to corporate debtor, which includes the framework under the IBC, jurisdiction, the legal provisions, insolvency application process by PG creditors, role of the RP in the PIRP process towards the IBBI, towards the NCLT, the moratorium and the legal protections, and then the repayment plans, how to draft the repayment plans, what should be the content of the repayment plan, then the discharge, termination, the case laws. And then we'll also covering the chapter 4, that is a bankruptcy order for the individuals and the partnership firms. Ministry of Corporate Affairs, by their notification dated 15th November 2019, had notified these provisions for the various sections which was effective from the first day of December 2019, which includes the provisions with respect to individual insolvency, which were section 78, except with regard to first start process, and section 79, section 94 to 187. In these provisions, all the provisions with respect to individual insolvency will be covered. And then many other provisions were notified with effect from the 1st April 2019, for this December 2019. Then the relevant legal framework. So in this individual insolvency, we have the rules, insolvency and bankruptcy application to adjudicating authority for insolvency resolution process for the personal guarantor to corporate debtor, rules 2019, which are applicable with respect to filing of the applications, forms, and many other things. And then there are regulations framed for the individual insolvency, which are the Insolvency and the Bankruptcy Board of India and Insolvency Resolution Process Personal Guarantor to Corporate Debtor Regulations 2019. The Bankruptcy Process for Personal Guarantors Applicable Framework, Insolvency and Bankruptcy Board of India, and these are the process for the Personal Guarantor Applicable Framework. The timelines of the key milestones in the PG insolvency under the IBC are the on 28th May 2016, IBC was enacted. The 15th November 2019, notification of relevant provisions of the code for the personal guarantors are invoked. 15th November 2019, the notification of the rules for the individual insolvency resolution process for the personal guarantors were notified. Then 20th November 2019, notification of regulation for the personal guarantors, and on the 1st December 2019, the effective date for the provisions of the rules and regulations for the personal guarantee insolvency. छुपा नहीं सकते। Then this is the the part of the individual insolvency which has been notified now is the only the personal guarantor to corporate debtor. This is the this is the part of the this chapters which has been notified till date. And there's a in the matter of the UCO Bank versus Subrata Das company petition number this, it in, it has been it has been held by this honorable NCLT Delhi bench that the legal positions enumerated above as it emanates from it in the decision rendered by the honorable Chief Justice Division Bench of the Madras High Court in Rohit Nagdis, we may safely conclude that in terms of section 60 subsection 1 and subsection 2 read with section 179 of the IBC, NCLT is the only adjudicating authority in respect of the personal guarantor to cooperator, whereas CRP or the liquidation proceeding initiated against a cooperator is either pending before the NCLT or is already concluded. In absence of a initiated or pending or concluded CRP against a principal borrower, an application under section 95(1) to initiate the insolvency resolution process against a personal guarantor to cooperator will not be maintainable before the NCLT. The recovery proceedings will lie only before the debt recovery tribunal, having the territorial jurisdiction. So they're saying that the CRP should have commenced for the initiating of the personal guarantor to corporate debtor. So I just want to take your views also that now I think the some new case laws must have come, which says that even in the absence of the initiation of the CRP, PIRP process can be started. Now, in many cases, I've seen that the CRP has not been initiated, but if there is a personal guarantor to corporate debtor, then the PRP process can be initiated. Chapter 3 is the insolvency resolution process for the personal guarantor to corporate debtors. So it now notified part is only the PG to CD, and the firm's personal insolvency against the firm is not yet notified, and for the other individuals also not notified. And once the PG to CD, the CRP liquidation should be in process, then as per this chart, the CRP liquidation process should be on for the initiation of the PG to CD. Section 60 is the adjudication authority for the corporate persons. Adjudicating authority in relation to insolvency resolution, the liquidation for the corporate person, including corporate debtor and the personal guarantor thereof, shall be the National Company Law Tribunal, having territorial jurisdiction over the place where the registered office of the corporate person is located. So if you want to invoke the personal guarantee, the PRP process, then the jurisdiction will be the NCLT, where the registered office of the CD is located. Subsection 2 of the 60 says that without prejudice to subsection 1 and outstanding anything to the contrary contained in the code, whereas CRP or liquidation proceeding of a corporate debtor is pending before the National Company Law Tribunal, an application relating to the insolvency resolution or the liquidation or bankruptcy of a corporate guarantor or personal guarantor, as the case may be, of such corporate debtor shall be filed before the NCLT. If the CRP process already initiated against the corporate debtor, then if you want to initiate the PRP process against some personal guarantor, then it will go in the same NCLT where the CRP is going on. An insolvency resolution process or the liquidation of the bankruptcy proceedings of a corporate guarantor or the personal guarantor, as the case may be, of the corporate debtor, pending in any court or tribunal, shall stand transferred to the adjudicating authority dealing with the insolvency resolution process or the liquidation proceedings of such corporate debtor. If some proceedings with respect to individual insolvency is going on in any other tribunal, any other court, then it shall stand transferred to the adjudicating authority dealing with the insolvency resolution process of such corporate debtor. This is all law with respect to the jurisdiction of the NCLT. Subsection 4 of section 60 says that the NCLT shall be vested with all the powers of the DRT as contemplated under part 3rd of this code for the purpose of subsection 2. And then subsection 5, we normally use subsection 5 that notwithstanding anything to the contrary contained in any other law for a time being imposed, NCLT shall have the jurisdiction to entertain or dispose of any application proceedings by or against a CD or the corporate person, any claim made by or against a corporate debtor or corporate person, including claims by or against any of its subsidiaries situated in India, any question of varieties or any question of law or facts arising out of or in relation to the insolvency or the liquidation proceeding of the corporate debtor or corporate person under this code. So, subsection 6 says,
these sections
notwithstanding anything contained in the
Excuse me.
Limitation Act 1963 or any other law for the time being enforced, in computing the period of limitation is specified for any suit or application by or against a CD for which order for moratorium has been made under this part, period during which the moratorium is in place shall be excluded.
Excuse me.
Yes, sir.
Acha, these sections under section 60, I think
Yes.
they are not clear as to where a case against a PG is to be initiated when CARP was not initiated.
Correct, sir. When the CRP is not initiated, this is not very clear where the case will go. But normally, we see that if the personal guarantor has given a guarantee in favor of a corporate debtor, so the case normally goes in the NCLT where the registered office of that corporate debtor is situated.
But I think some cases are lying with DRT also, it appears. I think in the last one of the webinars, somebody
Yes,
was saying the same doubt, and they were also not clear whether it has to go to DRT or NCLT.
I think a DRT has a jurisdiction with respect to individual insolvency, but for the with respect to PIRP, when there is a personal guarantor, then it is very clear from section 60 subsection 1 that the jurisdiction lies only with the NCLT. Now all the notified provisions of the act of the code does not confer any jurisdiction to DRT as of now because the individual insolvency has not yet been notified.
Yeah.
This is my understanding, sir. Yes.
But one case I think he has referred. I'll just come back. I'll just.
Yes.
I think I have noted it. Okay, sir. Proceed.
Yes. Then definition of the personal guarantor, section 5, subsection 22 says that the personal guarantor means an individual who is the surety in a contract of guarantee to the corporate debtor. Then to being a personal guarantor, there should be a contract of guarantee in favor of the these financial institutions or the bank. This is must for initiation of the PIRP process. Rule 3F of the IBBA application to AA rules provides that the guarantor means a debtor who is personal guarantor to a CD and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. Then the important part is that for initiation of the PRP process, we should invoke the guarantee before initiating this PRP process or filing of the application for the commencement of the PRP. There are many case law with respect to this also, that the invocation of the guarantee is must for initiation of the PRP process. Then initiation of insolvency resolution process for personal guarantor to cooperator, section 94, 95. This is a short of some comparison. A application can be filed by the debtor, and also it can be initiated by the application filed by the creditor. Section 94 deals when the application can be filed by the debtor for the initiation of the PRP. The 94 provides that the debtor may apply personally or through RP to A for insolvency process. In case of partnership firm, majority of the partnership firm yet not notified, application must not lead to excluded debt. So excluded debt is defined, we'll discuss later on in this seminar. And we cannot initiate the not eligible if debtor is undischarged bankrupt or the undergoing fresh start of the IRP or the bankruptcy process. So we cannot initiate the PRP if the debtor is undischarged bankrupt and undergoing fresh start process, or the IRP or the bankruptcy proceedings. Not eligible if application was admitted in last 12 months. Application to be in the prescribed form, manner, and with fees as prescribed in the rules and regulations. Section 95 provides that the application can be made by the creditors, and the creditors may apply individually or jointly as a consortium or via RP. The application can be filed by the RP also in the both the cases. Application for partnership debt may be against one or more partners, but this is not notified. We're not discussing this. 3 is the other partners application. This is also related with the partnership. Application must include debt details, 14 days payment default. So what is the 14 days payment default? Like, it is like we earlier discussed that we have to invoke the personal guarantee. Then for the invocation of the personal guarantee, we have to issue notice to the personal guarantor. And after issuance of this notice for the invocation of personal guarantee, this notice should be of the 14 days period. Evidence of default and non-payment. We should take all the evidence. The RP should be satisfied if it is filed by the RP or the creditor that there is a default or the non-payment by the debtor. Creditor must serve a copy of the application to the debtor. So whenever we are filing application for the initiation of the PRP, then the application copy must also be served to the debtor. Application to be in the prescribed form, manner, and with fees, and details documents as may be specified in the rules regulations. We have to file the application with the complete documents. There is a case that statutory notice issued on Form B under Rule 7(1) cannot be considered as valid invocation of guarantee pending proceeding under SARFAISI Act and sale of asset thereunder do not preclude initiation of proceeding under Section 95 of the IBC. In the case of the Central Bank of India versus Vinu Sagar, NCLT Kochi bench, the fact of the case is that the petitioner Canara Bank of India filed a petition under Section 95(1) of the IBC against Mr. Vinu Sagar, a personal guarantor, for defaulting on a debt of rupees 72 crores rupees. Corporate debtor Messrs. Jupiter Lease Private Limited was sanctioned a loan in 2012 for setting up a factory in Maharashtra, backed with the personal guarantees from Mr. Sagar and other individuals. Due to default, recovery proceedings were initiated under SARFAISI and the RT Act. One property was sold in an EU auction in 2019. CRP against the corporate debtor was admitted in December 2023. A demand notice in Form B was served on the guarantor in March 2024. Despite notice, repayment was not paid. Default was recorded in NESL on 28 December 2014. NESL is the information utility. Mr. V. Duraiswamy was appointed as a RP in September 2024 and recommended admission of the petition. The respondent challenged the petition, arguing that it was a premature due to the ongoing CRP and raised issue of limitation, sufficiency of the asset, and disputed debt validity. Legal issues in this case is that whether the petition under Section 95 of the IBC against a personal guarantor is maintainable during the pendency of the CRP against a corporate debtor, whether the claim against a personal guarantor is barred by limitation, whether the bank has validly invoked the personal guarantee as required by law, whether the statutory notice in Form B under Rule 7(1) constitutes valid invocation of guarantee, whether the pendency of DRT SARFAESI proceedings on or the status of the CD asset precludes action against the personal guarantors, whether the RP lands on the hypothecation deed affects the maintainability of the petition. So, this appellant or the defendant's argument in this matter was that since the CRP already initiated, therefore the Section 95 of the PRP cannot be initiated against a personal guarantor, because this company was the MSME company, and this directors had given the resolution plan for the corporate debtor. They were saying that the resolution plan will cover the debts of all the creditors of the corporate debtor, and it will satisfy all the creditors. Therefore, it is very harsh to initiate the PRP against the personal guarantors. Then they were saying that this is barred by the limitation because this loan was given in 2014, and therefore now this PRP is initiating in 2023. This is barred by the limitation. So in this case, if we go through the complete case, and the court says that since the noting is coming the balance sheet, and there is a now many judgments of the various of the UNCLAT and the Supreme Court that so once if any entity is reflecting the balance sheet, it will be deemed to be acknowledgement of debt. Therefore, it is not barred by the limitation. Then whether the bank has validly invoked the personal guarantee as required by law. Here in this case, what happened is that there were 2-3 personal guarantors. Notice was issued to SARFAESI, Section 13, subsection 2. Notice of the SARFAESI was issued to one personal guarantor. It was CC to other personal guarantors. In our case, the respondent is other personal guarantor to whom only CC was made. So it was held by the Honorable NCLT that since no proper notice was given to individual personal guarantor, therefore notice has not been served and the invocation of the personal guarantee has not been done. Therefore, the initiation of the PRP is bad in law, which we'll see in the conclusion part. Whether the statutory notice in Form B, Rules and 1 constitute valid invocation of the guarantee, we have to serve a demand notice that we intend to initiate the PRP, for which we have to issue a demand notice under Rule 7(1) of this code. But it has been held in this case that this issuance of the demand notice under Rule 7(1) does not constitute a valid invocation of the guarantee. There should be a specific demand notice which provides for the invocation of the guarantee. Then only we can commence the PRP process. Whether the pendency of DRT SARFAESI proceedings of the shares of CD assets, so they deal with all these provisions. And the conclusion is that the tribunal concludes that the petition under Section 95 of the IBC against a personal guarantor is not maintainable, as there was no valid invocation of guarantee against the respondent. So as I said that the demand notice or 13(2) notice was issued to one personal guarantor, not to this respondent of this case. Therefore, as per the court, as per the Honorable NCLT, held that this no valid invocation of the guarantee against the respondent is made. The statutory notice in Form B does not constitute valid invocation and petition is premature. Tribunal was found that the pendency of the CRP or the SURFACI DRT proceedings does not bar proceedings against the personal guarantor. But the procedural requirement of invocation of guarantee was not met in this case. Petition is dismissed. Petitioner is directed to pay cost of rupees 25,000 to NCLT defense fund. So this is case that it is important to issue a demand notice invoking the personal guarantee before start of the PRP process. Debtors not able to file application section 94(4), against whom we cannot file application under section application for the PRP is when the debtor is an undischarged bankrupt or the personal guarantor who is undergoing a fresh start process or undergoing a insolvency resolution process or undergoing a bankruptcy process. Against these persons, we cannot start the PRP process. Important part of this PRP and the CRP also is a moratorium. In the PRP process, there's two kind of moratorium provided. One is the interim moratorium, other one is the final moratorium. Interim moratorium provides in section 96 and the final moratorium provides in section 101. The interim moratorium commences from the date of filing of the application. When you file the application in section 94 or 95, interim moratorium commences till the admission of this application under section 94 95. Interim moratorium will continue. The final moratorium will commence from the date of the admission of the application filed under section 94 95 or the approval of the repayment plan, whichever is earlier. There is a provision with respect to interim moratorium, the final moratorium. We'll discuss in detail the provisions of the section 96 and section 101. Section 96 provides for the interim moratorium. Subsection 1A says that the interim moratorium begins from the date of the application under section 94 95 and ends upon admission of the application. So it starts from the date of the filing of the application. When we file the application in section 94 95, it starts and it ends upon the admission of the application. 1B says that during the interim moratorium, any pending legal action or proceedings regarding any debt is deemed stayed. Creditor cannot initiate any legal action or proceedings. So there are only two benefits provided under the interim moratorium. One is that any pending legal action or proceedings regarding any debt is deemed stayed. So any pending action will be stayed and no fresh legal action or proceedings cannot that if any we issue notice to the personal guarantor came to know that that the PRP is going to start against him, he may dispose of his personal assets or he may dispose of all his assets in between. There is no provision as there was in the section 14 that he cannot sell the assets or the dispose of the assets after the initiation of the proceedings. That kind of this restraint is not here in the interim moratorium. If the application leads to a firm, the interim moratorium applies to all the partners. This is not notified. The subsection 1 does not apply to transaction notified by the central government in consultation with the financial sector regulator. The central government says that interim moratorium will not apply on certain transactions. Such notification can be issued by the central government. Then section 90, the appointment of resolution professional. If the application under section 94 or 95 is filed through a resolution professional, the A shall within 7 days of direct the IBBI to confirm that no disciplinary proceedings are pending against the RP. IBBI shall within 7 days of receiving the direction from the A confirm the appointment of the RP or and nominate another RP. If the application is filed directly by the debtor to creditor or not through the RP, the A shall within 7 days direct an RP within 10 days of receiving the direction from the A under subsection 3. A shall appoint the RP as either confirmed under subsection 2 or nominated under subsection 4. The appointed RP shall be provided a copy of the application for the insolvency resolution process. Because this copy of the application filed either by the debtor or the creditor is very important for the RP, because all the details of the debt will be coming in the application. When we are filing the section 9 application, we will take all the details, mostly details we can get from this application filed by the financial creditor with respect to default, with respect to the non-payment of debt and total amount of liabilities. Everything we can get from the application filed by the financial creditor. Then section 98 provides for the replacement of RP. Debtors or creditors may apply to A for replacement of the RP appointed under section 97. A must refer the application to IBBI within 7 days of receipt. IBBI must recommend a new RP within 10 days, ensuring no disciplinary proceedings are pending. Creditors may also apply for the RP replacement approved by the creditors meeting for implementation of repayment plan. Then if the creditors want to change the RP, then it should be approved by the creditors in the creditors meeting. On admitting application under subsection 1, 2, or 4, A directs IBBI to confirm no disciplinary issues exist with the proposed RP. IBBI within 10 days must confirm appointment of the proposed RP or reject or recommend a new RP. Based on the IBBI response, A pass an order appointing new RP. Ongoing RP must share all relevant information with the new RP and cooperate in the transition process. Section 99 provides for the submission of report by the RP. This is the report filed by the RP, which should provide that this application for the initiation of the PRP process should be allowed or should not be allowed in the opinion of the RP. So this report is a basis for the admission of the application filed under section 94-95. So this is very important report to be filed by the RP. So subsection 1 provides that the RP shall examine the application under section 94-95 within 10 days of the appointment and submit a report to the A recommending approval or rejection. So he has to recommend approval of the application or the rejection of the application. The RP may ask the debtor to prove repayment by providing evidence of electronic transfer, evidence of check encashment, signed acknowledgement from the creditor. If application filed by the creditors, then the RP has to confirm from the debtor that he has this debt has been creditors, and he has to check from the debtor that if he has paid any amount back to the debt creditors by way of electronic transfer, evidence by check encashment, sign creditors, then RP has to take this confirmation from through email, he can send the email or any other mode of correspondence with the debtor to so that he can enclose with his report. If the debt is registered with the information validity, debtor cannot dispute its validity. RP may seek further information or explanation from the debtor, creditor, or any other relevant person. If RP thinks that he that to make his opinion that there's a default from the debtor's part and he needs some further information from the creditors or the debtors, he can seek further information explanation from the debtors, creditors, or any other relevant person. So he can write a mail to all those persons from whom he wants to check that there is a default. The person from whom information is sought must respond within 7 days of receiving the request. RP must ensure application meets the requirement of Section 94 or 95B. All information explanation sought has been provided. Based on the examination, RP shall recommend acceptance or rejection of the application in this report. If RP finds that the debtor is eligible for the fresh start, he shall recommend treating the Section 94 application as one under Section 81. RP must record reasons for recommending acceptance or rejection in the report. RP shall provide a copy of the report to the debtor or creditor as applicable. If it is filed with the debtor, the copy of the report should be served to the creditor also, and vice versa. So subsection 9 says the RP must record reasons for recommending acceptance or rejection in this report. So RP should satisfy himself that this case deserves for the approval or the rejection before filing his report. You can normally had seen that normally in the Section 99 report, nowadays Honorable NCLT asked RP to explain why this application should be approved or rejected. The relevant case law on Section 99. In the case of the Elsa Temi versus Arun Tani, role of the RP under Section 99 of IB is not merely administrative but also investigative in nature. RP is obligated to independently assess the financial conduct of debtor and report all material facts that bear upon the fitness of petition under Section 94. So he has to put his mind also in the form the investigative kind that this default exists and this admission application filed under Section 94, 95 can be admitted. It should not only be the administrative kind or the clerical kind that he just copied from the application filed by the creditors or the debtor, and he come to the conclusion that the default is made, therefore the PRP should be admitted. IBC is intended for genuine insolvency resolution, not as a tool to evade liabilities from the fraudulent conduct. Petitioners selectively disclose the history of the loan. In one case, what happens is that the petitioner was this personal guarantor only under Section 90 application filed under Section 94. Petitioners selectively disclose the history of the loan and default while suppressing key facts, which includes the prior order dated 25th January 23 of the by the NCLT directing repayment of 3.08 crores due to fraudulent siphoning of funds. And there's some pending contempt petitions which he has not mentioned in this application under Section 94. These omissions constitute a deliberate abuse of judicial process, warranting outright rejection of the petitions. The tribunal highlighted a critical failure on the part of the RP to bring crucial facts to its notice. Under Section 99 of the Code, the RP role is not merely administrative but investigative, requiring independent assessment of the debtor's financial conduct. In this case, it has been noted by the order of the Honorable NCLT that the RP failed to disclose prior findings of the fraud against the petitioners, pending contempt proceedings, ongoing default on a binding repayment order. This serious lapse is a duty undermining the integrity of the insolvency process and cast doubt on the credibility of the RP's recommendations. Tribunal recorded its dissatisfaction with duties in future. Petitioner claims of financial hardship was unsubstantiated. One is employed abroad in a managerial capacity, other has access to family resources. Kerala High Court permitted the international travel by family members, which contradicts claims of insolvency. The tribunal emphasized that non-disclosure by both the petitioner and the RP seriously compromised the process, especially considering the prior finding of the fraudulent conduct. It concluded that the petitioners' petitions were filed in bad BC framework. Ultimately, tribunal ruled that such action undermined the core objectives of the court, which is to offer a fair and transparent mechanism, not to escape route from legal accountability. The RP is to have a due diligence of the conduct of the personal guarantors, and besides the application filed by the creditors or the debtors, he has NCLT in his report in section 99. The admission or rejection of application. After the receipt of the report under section 99 filed with the RP, the adjudicating authority shall, within 14 days from submission of the report under section 99, pass an order of either admitting or rejecting the application filed under section 94 or 95. If the application is admitted to the RP, issue instruction for conducting negotiations between the debtors and creditors to facilitate a repayment plan. A shall provide a copy of the order. RP's report and the application under section 95 to the creditors within 7 days of the order. If the application is rejected based on the RP's report or due to fraudulent intent by the debtors, the A order shall state that the creditor is entitled to file for a bankruptcy order under Chapter 4. So, if it is admitted by the Honorable NCLT, then the copies of the application with all the reports should be served to all the stakeholders. And if it is rejected, the creditors are entitled to file for a bankruptcy order under Chapter 4. Now, 101 is with respect to moratorium. Now, if the case is admitted, application filed for the commencement of the PRP is admission, the moratorium commences, which provides in section 101. 101 subsection 1 provides that upon admission of application under section 100, a moratorium begins the earlier of the 180 days from the date of the admission or date when adjudicating authority passes order on repayment plan under section 114. So this moratorium will continue from the date of the admission till 180 days of the date of the admission or date when the order for the repayment plan has been passed under section 114. Repayment, once 14 provides for the approval of repayment plan filed with the NCLT.
So here
So this
there is a
moratorium-
chance for disposal.
Sorry, sir?
Here, under
Yes.
section 101(2), the
Yes.
sale can be done. Sale is also prohibited.
Yes. Here,
Like,
101.
under a moratorium.
In addition to the interim moratorium, it provides that the debtors cannot transfer, alienate, encumber, or dispose of any asset or legal beneficial interest. So it covers that part. Interim moratorium does not cover that part.
Yes, because it is not it was not admitted at that time.
Yes, yes. But then there is an opportunity with the PG that if you want to dispose of some of his asset, he can dispose of his asset because there is no restraint by the law that he
Yeah,
cannot sell the assets.
between interim and regular mode.
For restrain the personal guarantor to not to sell the assets. But there is no specific provisions after the admission start of the commencement of the PRP or the filing of the application that to restrain the personal guarantor not to sell his assets. Ah, this is a difference between the interim moratorium and the final moratorium. 1012 provides for the effects during the moratorium period, which provides that the pending legal actions proceedings for any debt are deemed stay. Creditors cannot initiate legal action proceeding for the debt. These two parts covers in the interim moratorium also. The new part is the subclause C, that debtors cannot transfer, alienate, encumber, or dispose of any assets or legal beneficial interest. This is the final moratorium. 1013 provides for the application under section 96 is for a firm. This is not applicable, not notified. 1014 is provides to provisions do not apply to transactions notified by the central government in consultation of financial sector regulators. So, moratorium will not apply to any transactions if notified by the central government in consultation with the financial sector regulators. Then 102 is provides for the public notice and claims from the creditors. Like in the CRP, we issue Form A here in section 102 provides for the issuance of the public notice. 102 subsection 1 provides that the adjudicating authority shall issue a public notice within 7 days of passing the order under section 100, inviting within 21 days of such notice. The provisions this provides that the A shall issue public notice, but normally in the order it has been assigned to RP only. RP only issues the public notice. In like in the CRP, here also he has to publish in one in the English language and one in the vernacular language, where the registered office of the company is situated. So all the creditors has to file their claim, whether the operational creditors, financial creditors. It does not make a difference of the financial creditor, operational creditors. Any creditors of the competitor can file their claim within 21 days of the such notice. Notice shall include details of order admitting the application. Section 100 application details should be mentioned in this notice. Particulars of the resolution professional, last date of submission of the claim. These details should be there in the notice to be published in the newspapers as per regulations. 1023 provides that the notice shall be published in one English and one vernacular newspaper in the debtor's state. It is saying that this notice should be issued in the debtor's state. If it can be interpreted that if the CD is in some registered office of the state, this notice should be published in the place where the debtors resides. And it should be affixed at the adjudicating authority premises. So normally when we publish the newspapers, we had to affix at the notice board of the relevant on NCLT this notice board and posted on the adjudicating authority website. So we have to get it posted on the adjudicating authority website. We can of the Honorable NCLT and request registrar to please to post it on the website of the adjudicating authority. So RP has to do all these duties while make the publication of the public notice as per section 1021. Then 103 provides for the registering of the claims by the creditors. 103.1 provides that the creditors shall register claims with the resolution professional by sending claims details via electronic communication, courier, speed post, or registered letter. Like in the CRP, all the financial creditors can file their claim by the electronic mode only. Here this provision provides that the claim can be filed either by the electronic communication, courier, speed post. Physical claim can also be sent by the creditors of the company. 1032 provides that in addition to claims, creditors must provide personal information, other prescribed particulars. Relevant regulation for claims is Regulation 7 of the PIP regulations. Regulation 7.1 says that the creditors must submit claims in Form B along with proof on or before the last date in the public notice. Cost of submission information utility or other documentary evidence substantiating the claims. RP may call for the additional evidence. RP may call for the additional evidence or clarification to verify the claims. RP must verify each claim and creditors under Section 1041 within 30 days from the public notice date. So within 21 days, he has to receive all the claims and to make a list of the creditors. If the claim amount is not precise, the RP must make a best estimate of the using available information. RP shall revise admitted claims if additional information is received after the repayment plan approval. We can revise the claims only till the date of the receipt of the repayment plan approval. The plan approval by the creditors meeting the RP has the liberty to revise the claims once the repayment, unless this repayment plan is approved by the meeting of the creditors. Claims in foreign currencies shall be valued in Indian currency at the official exchange rate on the resolution commencement. Explanation is there. The official exchange rate refers to RBI reference rate or one derived from it. This is all about the claims verification. Now, 105 provides for the repayment plan. The 105.1 says that the debtors, in consultation with the resolution professional, shall prepare a repayment plan proposing restructuring of the debt of the affairs. This repayment plan is to be made by the debtors in consultation with the resolution professional. The debtors should initiate the process of the making of the repayment plan, and the RP can help him in preparation of the repayment plan by advising the compliances to be made as per the provisions of the code. 1052 provides that the repayment plan may authorize or require the RP to carry on the debtor's business trade, realize asset of the debtors, administer / dispose of funds of the debtors. The repayment plan so made by the debtors in consultation with the RP may provide these things that that the RP can carry on the debtors' business trade and realize the assets of the debtors, all these things. 1053 provides that the plan shall include justification and basis for the creditors' agreement. So while drafting of the repayment plan, we have to see that it justifies the basis of the creditors' agreement, provisions for resolution professionals' fees, other specified matters. So all these things should be there in the repayment plan. The regulation 7 of the PRP regulations provides for the content of the repayment plan. 17.1 sub-regulations, regulation 17.1 implementation schedule, amount and date of repayment. How the personal guarantor will be implementing the repayment plan. The schedule should be there. In what time he will complete this process, this repayment plan. Sources of other PRP expenses should be provided in the repayment plan. Minimum at least 10% of the realizable income to repay debts. There should be provision for the guarantor realizable income to repay debts. This D provides for the financing for implementation, management of guarantor's business, if any after the approval of the repayment plan, RP assigned the duty of the taking care that the repayment plan is implemented properly, and then only the RP has to report to the NCLT that the plan has been completely implemented. Variation of the one-risk contract terms, details of excluded assets and debts, discharge terms for guarantors. Once the repayment plan is completed, then what would the discharge terms for the guarantor? 17.2 provides the plan may also provide for the transfer or sale of assets, administration, disposal of funds, satisfaction, modification of security interest, reduction in amount payable, curbing, waiving of debt breaches, modification of the repayment terms, allocation of guarantor income and income calculation method, treatment of unrepaid funds after plan ends, other matters required by creditors. All these things should in subsection 14 provides for the excluded assets. The certain assets against which we cannot creditors cannot claim to be distributed to amongst the creditors in the repayment plan, which are any unencumbered personal ornaments of such value as may be prescribed. The unencumbered furniture, household equipment, and provisions as are necessary for satisfying the basic domestic needs of the bankrupt and his immediate family. Unencumbered tools, books, vehicles, and other equipments are necessary for his personal use or for the purpose of his employment, business, or occasions. Any unencumbered life insurance policy or pension plan taken in the name of the debtors or his immediate family. Any unencumbered single dwelling units owned by the debtors of such value as may be prescribed. So, if the debtor has more than one residential property, then he can retain one residential property for himself. Apart from all these things used for the daily livelihood of the personal guarantors and his immediate dependents. So these are the excluded assets. Excluded debts also, which provides in section 79.15, which personal guarantor has to pay from his own sources and cannot be part of the repayment plan, which are damages, maintenance, student loan, fine imposed by any court or tribunal, or any other debt as may be prescribed. So these will be the excluded debt, which is defined in section 79.15. Section 104 provides for the preparation of the list of creditors. 1041 provides that the RP shall prepare a list of creditors based on information disclosed in the application filed under section 94 or 95 as applicable. Claims received under section 102. The list must be prepared within 30 days of the date of the public notice. The RP has a duty to make a list of the creditors and within 30 days from the date of the public notice. And it can be shared amongst the stakeholders, like if the creditors wants the list of creditors, RP can share the list to the creditors. Regulation 7 provides for the list of creditors. Regulation 7 also provides for the list of creditors in the PRP regulations. Sub-regulation 9(1) says that the list must include name of the creditors, amount claimed, amount admitted, security interest if any. So this must be the basic contents, uh, uh, contents of the list of creditors. Like they had the list provides for all these things. The sub-regulation 9(2) provides that the resolution professional shall make the list available for inspection to claimants. Serve a copy to the guarantor. Present the list at the meeting of the creditors. File a certificate copy with the A along with the repayment plan. It is also one of the duty of the RP to file this list certificate copy of the list of creditors with the A along with the repayment plan. Section 104 list of creditors. RP prepares list of creditors on the basis received by the RP. The resolution professional shall prepare the list within 30 days. Is the same thing. Sorry. Section 106 provides for the report of resolution professional on repayment plan. Section 106(1) says that the resolution professional shall submit the repayment plan under section 105 along with the report on the plan to the A within 21 days from the last date of submission of the claim under section 102. Thus, 106 provides that the repayment plan, if received by the RP under section 105, then RP has to make his report about the repayment plan, that this plan is compliant, like we do in form match in CRP process. And then we had to submit this plan with the A within 21 days from the last date of submission of claim under section 102. So the last date of submission of claim is 21 days. In additional 21 days, like in 42 days from the publication of notice, we have to submit this repayment plan with the A along with the report of the RP. 106(2) says that the report shall include confirmation that the repayment plan complies with the applicable law, opinion that the repayment plan has a reasonable prospect of approval and implementation, and the necessity of summoning a creditors meeting if required, provided if no meeting is recommended, reasons must be given. 106(2) says that what would the contents of the report to be issued by the resolution professional? The contents of the report of the resolution professional is that the repayment plan complies with the applicable law. Then that this repayment plan is can be implementable, is reasonable with respect to the asset size of the personal guarantor. It can be implemented, and also he has to mention in this report that there is a necessity of summoning creditors meeting or not. If he in his opinion that meeting should not be called, then he should provide the reasons for that. 106(3) says that if a meeting is to be summoned, report shall specify the date, time, and place of the meeting. So it means that if the meeting is to be summoned, so firstly, if you want to convene a meeting of the creditors, then he has to firstly issue a notice, and he has to provide the date, time, and place of the meeting in his report. 1064 less than 14 days and not more than 28 days of the report submission date. Date of meeting shall not be less than 14 days and not more than 28 days for the report submission date. The regional RP shall consider the convenience of creditors while fixing the date and venue of the meeting. This is all. And section 107 is about the summoning of the meeting of the creditors. And correspondingly, the regulation 11 is there with respect to the meeting of the creditors. So section 107(1) provides that the RP shall issue a notice to the creditors meeting at least 14 days before the meeting date. So minimum period provided for the calling of the meeting of the creditors is 14 days. We have to issue the 14 days notice. Then 1072 provides that the notice must be sent to all the creditors as per the list prepared under section 104. 1073 says that the notice shall mentions the address of the adjudicating authority and be accompanied by the copy of the repayment plan, copy of the statement of office of the letter, report, proxy voting form. So this notice to be prepared under section 1071 for the creditors. And he also has to make a statement of affairs. It will be covered later in this that is provided in the regulations. The basic contents of the statement of office of the personal guarantors. He has to enclose the copy of the this statement of office of the letters and copy of the resolution professionals report and proxy voting forms. Electronic proxy voting shall be then regulation 11(1) provides that only creditors included in the list can participate in the creditors meeting. Voting share of each creditor is proportional to the debt owed by them. It is in same form as in the CRP. 11(3) provides the RP shall convene the first meeting of the creditors in accordance with subsection 1 of section 107 and shall convene meeting by giving such notice to other participants as decided by the creditors, which should not be less than 48 hours. If you want to invite somebody, then this invitee should be given notice of Regulation 11(4) provides a meeting must be convened if requested by the creditors having 33% of voting share. Or if any creditors wants that the meeting should be conducted by the RP, then the creditors having 33% or more voting share can ask RP to call a meeting of the creditors. 11(5) Regulation 11(5) provides that the notice shall be served at the creditors at the address provided by the participant under Regulation 12. 11(6) says that unless otherwise the resolution placed in the creditors meeting can be passed if it is approved by more than 50% of total voting shares of the creditors who voted. The resolution will be deemed to be passed. 108 Section 109 provides for the voting rights. The 1081, the meeting conducted as per section 108 to 1011. With respect to conduct of the meeting of the creditors is 108 subsection 2 provides that the creditors may approve, modify or reject the plan. 1083 provides that the debtors' consent needed for any modifications. If creditors want that the repayment plan should be modified, then they cannot directly modify the repayment plan. They have to take the consent of the debtors also, because primarily it is a duty of the debtor only to make his repayment plan. 1084 provides the meeting can be adjourned maximum 7 days. Like if creditors in their meeting is of the opinion that the repayment plan should be modified, and if the debtor is also there, and debtor agrees that he is ready to modify his repayment plan, the meeting can be adjourned, but it that the creditors vote as per voting share. 1092 provides RPA assigns voting share as per the board guidelines. 1093 provides no vote for unliquidated debts. 1094 provides if no vote if not on list of or his debtors associate. If any debtors, he is not in the list of the creditors, and he don't have any right to vote. The regulation 12 provides for the notice must include date, time, venue, agenda to VC or e-voting details. The regulation 13 provides that the quorum of the meeting, creditors meeting, should be at least 33% of the voting share. It will be adjourned if the minimum quorum is not there in the meeting. Regulation 14 provides that the RP presides. He asks for the roll calls, restricted access during the meeting. Sub-regulation 1.2 provides that the voting after discussion minutes includes the name of the creditors who voted for or against or abstained from voting on the items put to vote in the meeting. Regulation 15.325 provides that the circulate minutes in 48 hours, open e-voting for. It is same as in the CRP. We have to circulate minutes in 48 hours, then open e-voting for 24 hours at least, and share results after the e-voting result in 24 hours. Regulation 16 provides for proxy voting allowed. Submit Form C24. Submit Form C 24 hours prior to e-voting or by proxy allowed. There is a new provision 17A. This is also with respect to meeting of creditors. Earlier, it was not very clear in the code, either by the section or by the regulation, that if the repayment plan has not received during the PRB process, or if it has been rejected by the meeting of creditors, then whether it is essential to call the meeting of the creditors or not. Now it has been clarified now in section 17A. It says that the RP shall present the repayment plan as well. If any repayment plan has come, then he has to place that repayment plan in the meeting of the creditors first for the constitution of the creditors. If no repayment plan is received within time 06, RP shall notify this fact in the meeting. Even if the no repayment plan has received, then also RP has to convene a meeting of the creditors, and he has to notify this fact that the no repayment plan has been received. This is new regulations which clarifies that even if the no repayment plan received by the in the PRB process, then Mittal, NCLT New Delhi bench. The fact of the case is Kavir Vesa Bank filed application under section 95(1) of the code against Mr. Vishnu Mittal, guarantor. Tribunal appointed Mr. Shruti Gupta as the RP for the debtor's personal guarantor as per order at this. RP carried out the process according to section 99 of the IBC, submitted a report recommending admission of the application under section 95(1), which was accepted by the tribunal on 2nd December 2024. In this matter, no repayment plan received, and the section 99 report has been admitted. Okay. RP filed IA 1210 of 2025 alleging non-cooperation from the personal guarantor who did not respond to communication from the RP. Was received as on date of the filing. In this case, it was decided on 2nd July 2025. So, as on this date, this Regulation 17A was notified, has come into effect, and the Honorable NCLT held that this provision of 17A, then even if the no repayment plan received, then also RP has to convene a meeting of the creditors to notify the fact that the no repayment plan has been received. So RP has to conduct a meeting of the creditors even if the no repayment plan received. Regulation 18 is purchase of assets by certain persons. The following persons cannot purchase or acquire any interest in the guarantor's property directly or indirectly without permission from the IA. So these persons is the RP or any partner director of the IP, the RP is associated with, the professional appointed by the RP for the resolution process, any creditor, any company where the guarantor or the creditor is a promoter or director. To any associate of the guarantor, creditor or RP. Regulation 2 of Regulation 18 provides that the AA may set aside such purchases made in contravention of this regulation and may it deems fit. These persons cannot purchase any. Now there is a provision with respect to secured creditors, section 110. 110 provides for the rights of the secured creditors. In the PRP regulation, this secured creditors has been defined in section 230, means a creditor in favor of whom security interest is created. Section 231 provides for the security title interest or claim to property created in favor of a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, encumbrances, or any other agreement or arrangement securing payment or performance of any obligation of any person, provided that security interest shall not include the performance guarantee. So this section 110 subsection 1 provides that the secured creditors may participate and vote in the creditors meeting. So the secured creditors also has to file their claim with the RP, and RP after admission they come into list of creditors and they can participate in the meeting of the creditors. If a secured creditors votes, they forfeit right to enforce the security during the repayment plan period if the plan as per the plan terms. If the secured creditors votes on their as per their voting rights, then it is deemed that they are forfeiting their right to enforce their security interest during the repayment plan period. If the secured creditors wants to retain enforcement rights, they must submit an affidavit at the meeting stating that voting is only for the unsecured portion and estimated value of the unsecured part. So 110(3) provides that if secured creditors wants to retain enforcement rights, then they must submit an affidavit at the meeting of creditors. So whenever RP is calling the meeting of the creditors, then at that meeting he has to submit an affidavit saying that the voting is only that he has a right to vote only for the unsecured portion, and what is the value of that unsecured portion. Then he has to apportion his total claim admitted in the secured interest and the unsecured interest. For the unsecured interest, if affidavit is submitted under section 110(3), this 110(5), if the secured creditor does not vote but the plan affects enforcement rights, their concurrence must be obtained. If the repayment plan says that as any provisions which is affecting the enforcement rights of the secured creditors, then their period of the repayment plan means the period from the date of the order passed under section 114 till the date on which the notice is given by the RP under section 117, or the report submitted by the resolution professional under section 118, as the case may be. So what will the period of the repayment plan? Is provided in explanation to section 110, which says that the period of the repayment plan will be from the date of the admission of the repayment plan in terms of section 114 till the date on which the notice is given by the RP under section 117 that this repayment plan is fully implemented, or the report submitted by the RP under section 118, as a case may be. Till the period of repayment plan is defined in the explanation of the 110. Approval report non-submission of filing provides in the section 111 to 113, and relevant regulation will be regulation 17 being 17 and 19. Section 111, 111 provides that the repayment plan or any modification must be approved by at least 75% in value of the creditors present and voting in person or by proxy. This repayment plan should be approved by at least 75% in value of the creditors present in the meeting of the creditors. 112(1) says that the RP must prepare a report of the creditors. RP must prepare a report of the creditors meeting on the repayment plan. 112(2)(a) provides that the state whether plan was approved or rejected and list modification if any. 112(2)(b) provides that includes the resolution proposed and their decisions. 112(2)(c) provides for the list of creditors present, represented, and their voting records. 112(2)(d) provides for any other information the RP considers relevant for the adjudicating authority. Section 113 provides that the RP must provide a copy of the report under section 112 to debtors, all creditors, even if absent, authority. So RP, after the approval of repayment plan, has to provide a copy of his report to debtors, all creditors, even absent, on to the adjudicating authority. Regulation 19(1) provides RP must file the approved repayment plan report under section 106 or 112 with the AA within 120 days from the resolution commencement date. Regulation 19.2 provides RP must provide a copies of the filed documents to guarantor and creditors within 3 days of the submission. All the repayment plan application filed with the NCLT has to be also provided to the guarantors and the creditors within 3 days of the submission of the repayment plan. 17B provides if no repayment plan is submitted by the debtor under Section 105, RP shall apply to A with creditors' approval for appropriate directions. If no repayment plan received, then RP as per 17A has to convene a meeting of the creditors to notify the fact that the no repayment plan received, and then has to apply to the A also for the appropriate directions. Normally, it is the closure of the PRP process. Section 114 to 117 is adjudication, binding effects, and completion of the repayment plan. Section 114 provides that the order of adjudicating authority on repayment plan. And 14.1 provides that the adjudicating authority shall approve or reject the repayment plan based on the report from the resolution professional under Section 110. And 14.2 provides that the approval order may include directions for implementing the plan. And approved by the Honorable NCLT. Necessary, it may direct RP to reconvene a meeting of creditors. So A can also, if in the opinion of the A, if the repayment plan requires any modification, then it may direct the RP to reconvene a meeting of creditors and get the plan modified and place it again for the approval of the meeting of creditors. It has the power under Section 114.3. 115.1 says that if approved, the repayment plan takes effect as if proposed by the debtor, becomes binding on all the creditors and the debtors. 115.2 provides that if rejected, debtors or creditors may file for bankruptcy under Chapter 4. 115.3 provides that the copy of rejection order shall be sent to the IBBI for updating the register under Section 196. Then Section 116 provides for the implementation and supervision of the plan. 116.1 section provides that the RP appointed under Section 97-98 shall supervise the implementation of the repayment plan. This is only RP who has to supervise the implementation of the repayment plan. Become part of the order for the where this repayment plan is approved by the A. 116 2 provides that the RP may apply to the A for directions regarding regarding any issue under the plan. 116.3 A may issue appropriate directions for RP application. This is all about this implementation and supervision of the repayment plan. Then 117 provides for the completion of the repayment plan. After this plan, all the terms of the repayment plan has been RP within 14 days of the plan completion shall submit to the A and bound parties notice of plan completion, report summarizing receipts, payment, and extents of the implementation. RP may apply for extension up to 7 days to file the above documents. So after the completion of the repayment plan, RP has to file his report within 14 days of the plan completion. As per section 114 of the IBC, adjudicating authority needs to approve or reject the repayment plan on the basis of the report of the meeting of the creditors, of the report of the RP. In the matter of the Amrit Pal Chadda, personal guarantor, decided by the Principal Bench, New Delhi. The present application was filed by the RP under section 112 of the IBC, seeking approval of the repayment plan of Mr. Chadda, repayment plan, the personal guarantor to a corporate debtor under section 114 lead with section 115(1) of the IBC. Application also seek continuation of a 300 days delay in filing the repayment plan and adjudicating authority found that the repayment plan dated 10th November 24 as revised and accompanied by the addendum was duly approved by the requisite majority of the creditors, which is 75% of the total number present and voted, complied with all the statutory regulatory requirements, and was recommended by the RP that plan should be approved, and it is a compliant plan. The A found no impediment to the approval and accordingly approved the plan, issuing direction for its implementation and discharge of the personal guarantor upon full compliance. Application for approval of repayment plan is allowed and disposed of. Repayment plan of 4.65 lakh approved with from date of the order, subject to directions specified by A. Normally, this kind of order passed by the while approving the repayment plan. The premature termination of the repayment plan and the breach of repayment plan by the guarantor. There may be condition that the debtor fail to comply or implement the repayment plan, and the repayment plan terminates in between without the full implementation of the plan, or there may be the breach of the repayment plan by the guarantor. Section 118 provides for the repayment plan coming to an end prematurely. Section 118(1) provides that the repayment plan ends prematurely if not fully implemented within the period stated in the plan. 118(2) provides that if prematurely ended, the RP shall submit a report to the A stating that the receipts and payment made, reasons for premature end, details of the unpaid creditors. And it is duty of the RP that if the repayment plan is prematurely ended, he has to file a report with the A saying that all the receipts as per the repayment plan and the payment made to all the creditors as per the repayment plan, and then he has to mention that what are the reasons for the premature end of the repayment plan and details of all the unpaid creditors. He has to mention all these things in his report to the A. 118(3) of this provision of the code provides for the debtors or unpaid creditors may apply for a bankruptcy order under chapter 4. RP report is ordered under subsection 3. The A shall forward all their order to all the person who was bound by who was affected by this premature termination of the repayment plan. 118(6) provides that the A shall send a copy of the order passed under subsection 4 to the Insolvency Board for record under section 196. Regulation 20 provides for the breach of the repayment plan by the guarantor. If there is a that situation. 21 Regulation 21 provides that if the RP believes that the guarantor has failed to implement the plan, RP issue notice within 3 days, requiring response within 15 days. Guarantor must address the failure. If the RP or any terms of the repayment plan has been breached, then RP shall immediately notify to the personal guarantor within 3 days of his knowledge, and then the personal guarantor is obligated to respond to the RP notice within 15 days from the date of receipt of notice. In the response, the guarantor must also provide for the reasons for the failure or the breach of the repayment plan, and as a failure, he will make good the failure repayment plan, and they provide for a valid explanation why this repayment plan has been provisions of repayment plan has been placed, and he is taking care of rectify the same. 22 provides that if the guarantor complies or explains satisfactorily, RP shall inform the creditors within 7 days of the date of failure, addressed or explanation provided for such failure. Then all the response received, or if the breach on the repayment plan has been addressed, then RP immediately has to notify to the creditors within 7 days of the notification received from the guarantor. 23 provides that if not is over, RP may apply to A under section 116(2) for directions if the failure affects implementation. If this breach in the repayment plan has not been resolved even after the notice by the RP, then the RP has the duty to apply to the A under section 116(2) for directions, and firstly notifying all the breaches made by in the repayment plan, and for necessary directions from the A. Then section 119 provides for the discharge order. 119(1) provides that the RP shall apply to the A report, then RP shall apply to the A that this personal guarantor should be discharged. Or discharge upon full implementation. So repayment plan may also provide for if the repayment plan is say for the 1 year, 1.5 year, in this case I will make payment majority of payment at this time and request for the early discharge, then it can provide the early discharge, and the A may issue necessary direction for the early discharge of the personal guarantor or discharge. Otherwise, the discharge will happen only upon the full implementation of the repayment plan. Discharge order to be sent to the board for updating the registers under section 196. And discharge order does not release any other person from liability on the same debt. Say if there are 2-3 personal guarantors or the corporate debtor, and this PRP started for the common debt of the, and repayment plan provides for the payment of the part amount of this debt of the corporate debtor, then the only discharge orders will be only for this personal guarantor of which the PRP is going on, not for the other persons also owns the same debt. Regulation 21 provides for the application for discharge order. 21(1) says that the RP shall file the discharge order also, a separate application should be filed by the RP for the for discharging the personal guarantee. 21(2) regulations provides that the A, upon reviewing the notice and report, may pass the discharge order accordingly. Once the PRP applications filed under section 94 or 95 can be withdrawn.
No provision for withdrawal. Hello. 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 Hello.
Sir, I'm audible?
For you're not audible, sir. Now you are audible.
Okay. Uh,
Talking about withdrawal of PG to CD cases.
okay. So, okay. Should I, sir, repeat again from where I was not audible?
Yes, sir.
Yes, yes, ma'am. So, sir, should we continue from here, sir? Forms? Hello? Hello? Hello?
हेलो
Yes, sir.
सर लंच ब्रेक दिया है
Yes, sir.
हाँ
Sorry, sir.
सर वी आर अनेबल टू लिसन एनीथिंग ब्रेक दिया है क्या
नहीं, हाँ सर, ब्रेक अभी नहीं दिया, कुछ टेक्निकल प्रॉब्लम आ गया, जस्ट करेक्टिंग। जूम कैसे खुलेगा?
ठीक ठीक है ओके
और वी कैन हैव मिनट्स ब्रेक, सर।
सर एक वॉशरूम ब्रेक दे दो 5 मिनट प्लीज
हाँ सर, 10 मिनट का वॉशरूम ब्रेक दे देते हैं, है ना?
ठीक
विल
है
रिज्यूम एट 1:10।
हाँ यस सर
ठीक है, राइट सर। हैं?
टाइम लिमिट की वजह से
किसके टाइम लिमिट? उसका?
जूम का
उसका है ना, ये दिख क्यों नहीं रहा? इसको तो बंद कर दो। उनका लिंक है ना, खुल ही नहीं रहा।
दोबारा ज्वाइन कर ये नहीं गया था
हम्म।
बाबा
Can we restart?
Yes, sir.
Yeah. So these are the forms provided in this regulations. Form A is for the application by guarantor to initiate the insolvency resolution process. It is under Rule 6 of the PRP rules 2019. It should be addressed to the adjudicating authority. And in this form, we have to provide the details of the personal guarantors. In part 1, the full name, date of birth, and the address and occupation, everything. Income, identification number, contact numbers, then the list of assets of the guarantor and immediate family members as on the application date, which is the movable property, immovable property, description, estimated value, excluded assets, if any. It all the details has to be provided by the personal guarantor in this form. Then the movable assets, the nature of directorship held in the last 3 preceding years, and marital status, details regarding guarantees, CD and everything. If whether guarantor is not a resident in India, the name and address of the person authorized to accept service of process on guarantor's behalf along with the authority. In the part second, we have to this personal guarantor in section 94 has to provide the business particulars of a guarantor, name of the business, form of the business, details, description of business, business address, annual income guarantor, date of joining of the firm or capital subscription as per latest balance sheet. This all details has to provide with the personal guarantor. And the part third, he has to provide the particulars of debt, creditors wise as applicable. The name of the creditors, he has to provide the creditor wise. Like if the first creditor is the SBI, then he has to provide the name of the SBI, then address of the creditor, total debt due to the creditor as on date of the filing of this application, amount of debt, interest, penalties, date when the debt was due, date when the default occurred, nature of debt, every details he has to provide with respect to debts in part 3. Then he has to attest that the confirm that the all the particulars he is providing this form is all correct. And he has to also undertake that he is not including any excluded debt in this thing. And he is notify if he is recommending any RP, then he also provides the particulars of the RP, name and details of the RP, and then he has to declare all the particulars are true and correct. This is the form to filed by the personal guarantor for initiating his insolvency under section 94. And if he is recommending some RP, then RP also has to undertake, has to confirm that his details, his number of assignments, that he's consenting to act as the RP of this in this PRP process. All other details as mentioned in this form. Then there is form B. Form B is for the demand notice. This is a statutory notice to be issued by the personal guarantor or the creditor for issuance of the demand notice, and it is to be issued under Rule 7.1 of the PRP rules 2019, address of the guarantor, because it is if it is being issued by the financial creditor, it will be issued to in the name of the guarantors. And we had already discussed that this is a statutory notice to be issued before the initiation of the PRP, and it cannot be deemed that it is a notice, demand notice for the invocation of the personal guarantee. So demand notice in respect of the unpaid debts in default due from the personal debtors under the code, and in this demand notice, We have to mention the particulars of the debt, amount of debt in default, debt when due, debt when that date when debt was due, date when the default occurred, nature of the debt, secured debt, including particulars of security held, date of creation. So he also has to mention this details of this is security interest, if any, unsecured debt. Like we had mentioned that he has to, if he has a secured interest, secured debt, then he has to mention the value of the secured debt and value of the unsecured debt. Details of the retention of the title agreement, particulars of any order of court, tribunal, arbitral panel, adjudication on the default, if any, record of default with the IU, information utility, details of succession certificate of probate or will, and provision of law, contract, or other document under which the debt has become due, statement of bank account where deposits are made or credits received, normally by the creditors in respect of the debt of the corporate debtor from the date on which the debt was incurred. So, creditor also has to provide for the details of his bank accounts. Then he has to verify this form and that all the contents of this form is correct. Then there is Form C. Form C is for the application by creditors to initiate the insolvency resolution process under Section 95, as we discussed. It is filed under Section Rule 7.2 of the PRP Rules 2019. That is to adjudicating authority. And here, since this form is being filed by the financial creditors, the particulars of the applicant will be the financial creditors who has in whose favor the personal guarantee has been issued. So voice is coming, I don't know. Particulars of applicant, date of birth, because the financial institution there will be no date of birth, then all details of the personal nature of the financial creditors applicant has to be filled. Then particulars of the guarantor in part second has to be filled. Please I will post. Sir, you can see my screen, like PPT.
I think you have paused it just now.
I think, yeah, it is not visible.
Okay. Now it is visible?
No.
Or no?
It is visible, sir, now?
No, sir, not. It
No?
is showing it's passed. Ashish Singh has passed this screen sharing.
Oh, okay. It is visible now, sir? Visible, sir?
Yes. Now it is visible.
Okay, sir. Thank you.
But make it screen little bigger. Huh?
Yes, sir. It is okay, sir, now?
Yeah, I think a little. Yeah.
पण आघाडी सुरू पप्पा भी लेवन कधी
The Form C, we are discussing Form C.
હવે થોડું આખ્યાન દીખણ ત્રાસ હોય ટુ વ્હીલર મોપેડ ગામમાં જાવણું રહે બેને એક મિંદર સિવાય શક્ય તો કટે જાવણું રહે.
So please mute yourself, sir.
Yes, muted, sir. Sorry.
So this Form C is to be application to be filed by the creditor to initiate insolvency resolution process. We discussed that the creditors can file application for the PRP in Section 95. Then they have to initiate the PRP. They have to fill this Form C for as an application into the adjudicating authority, and they have to fill all the details as mentioned in this Form C. In part one, they have to fill the details of the applicant. Applicant are normally the financial creditors here. In part second is the particulars of the guarantor. They fill all the details of the guarantor. Details of assets of the guarantors in their knowledge. The same immovable property, movable property with estimated value, and the excluded asset if they are in the knowledge. What are the excluded asset and excluded liabilities? Then they also has to provide the details of the directorship of the personal guarantors if they have these informations, and all other details with respect to business of the personal guarantors. In part 3, they have to provide the particulars of the debt, total debts, amount in default, date on which the debt was due, date on which the default occurred, nature of the debt, secured debt and unsecured debt, value wise, details of retention of title agreements, if any, in respect of goods to which the debts refers, and all details of any mutual credit, mutual debts, or other mutual dealings which may be set off against the claims, particulars of an order of a court, tribunal, adjudication on the default, if any, record of default with the information utility, details of succession certificate or probate of a bill, provisions of law, contract, or other documents under which debt has become due, statement of bank account where deposits are made or credits received first normally by the creditors in respect of debt of the corporate debtor, and list of documents attached to this application in order to prove the existence of that and the amount in default. Then creditor has to verify this application and they has to file this application in Form C for the initiation of the CRP process. Part 4 is the particulars of declaration of the insolvency professional application filed through insolvency professional. If they are recommending some RP, then they have to provide the details of the insolvency professional, the title name of the RP and the address, email address, contact number, and there should be some declaration by the insolvency professional about his registration, everything, and he is eligible to take this assignment. Then this next form is Form D. Form D is for the application of withdrawal of insolvency resolution process, as we discussed. This is for the withdrawal. Withdrawal can be done before the admission of the PRP, before the admission order under Section 100. Then it can be withdrawn by the consent of the applicant and the A, and in case it has been admitted by the NCLT, then it can be withdrawn after taking the consent of the 90% of the creditors in the meeting of the creditors. The details of the withdrawal application is provided here, why they want to withdraw and all the reasons for the withdrawing this application. Now the next part of this individual insolvency is chapter 4, which is with respect to bankruptcy order for individuals and the partnership firms. Now since the partnership firms has not been notified yet, it is only for the individuals. So now we are discussing the bankruptcy order for the individuals. In case we discussed in the 3 part where if the repayment this PRP process fails, resolution process for the individual insolvency, like if the 94-95 application rejected by the NCLT, then the debtors or the creditors can file for the bankruptcy order. If the 99 reports, after 99 report, RP recommends for the rejection of the PRP process, then also creditors or the debtors can file for the bankruptcy order. Or if the repayment plan fails, or if the repayment plans has been rejected by the NCLT, then also the debtors creditors can file for the bankruptcy order. So whenever this PRP process fails, then the debtors or creditors can file for the bankruptcy order for the individuals. So section 121 provides for the application for bankruptcy. Application can be made by creditors individually or jointly, or by debtors only after certain prior orders by A under section 104, 115.2, 118.3, as we discussed, must be filed within 3 months of these orders for firms. Any partner can file the application. So for the partnership, this has not been notified. 122 is for the application by debtor. Must include records of the insolvency resolution process, statement of affairs in prescribed form, copy of adjudicating authority order permitting application. Debtors may propose an insolvency professional as bankruptcy trustee. Here the RP is called the bankruptcy trustee in this part of this chapter code. Application in prescribed form and fees to be paid. And once application filed, it cannot be withdrawn without the court permission. Court permission is must for the withdrawal of this application for the bankruptcy. Then section 123, 124 and 125 is with respect to application by creditors. In the application by creditors, what will be the contents of the application of creditors? It must include the records of the insolvency resolution process. The records may include that why it fails, copy of the adjudicating authority orders permitting application, details of debt owed or others orders prescribe information for secured debt, either give of security for benefit all creditors or specific unsecured part of and its estimated value, as we seen in the form filed by the financial creditors. They had to provide the secured part of their debt and unsecured part of their debt. Secured and unsecured part treated separately. Creditors may propose insolvency professional can appeal against legal representatives if debt is deceased. Can apply against legal representative that is deceased. Application prescribed form and fees cannot withdraw without permission. Effect of application on filing application. Interim moratorium starts on action against debtors' properties. Moratorium lasts until bankruptcy commencement. Pending legal actions are stayed. Creditors cannot initiate legal proceedings. The moratorium applies to all the partners. Like 124 is the moratorium period for in the case of the bankruptcy. 125 is the appointment of insolvency professional. If the insolvency professional proposed in the bankruptcy, the adjudicating authority directs IBBI to check disciplinary status within 7 days. IBBI confirms or rejects within 10 days. If rejected, IBBI nominates another trustee. If no trustee proposed, then adjudicating authority directs IBBI to nominate trustee. IBBI nominates within 10 days trustee appointed by A in bankruptcy order. Section 126 provides bankruptcy order passed within 14 days of trustee confirmation. Copy of application order given to bankrupt creditors and trustee within 7 days. Initiate formal bankruptcy, effect on parties. Ensure official notice to all the parties. So once this bankruptcy order has been passed against the debtor, then all the implications with respect to bankruptcy will apply on the debtor. Bankruptcy order remains effective until debtors discharge under section 138. Debtors remains under bankruptcy restriction until discharge. 128 provides that the estate vests in trustee and divided among creditors. Creditors cannot sue unforced claims without permission. Secured creditors keep rights but must act within 30 days. Applies to individual partners in firms. Trustee gains control over assets, freezes creditors' action, protects secured creditors' right. This is the effect of section 128 when this bankruptcy order comes into effect. Section 129 provides that the bankrupt submits statement of financial position within 7 days. Firms submit joint individual statement. So bankrupt or the debtor now becomes a bankrupt of the bankruptcy order, has to submit his statement of the financial position within 7 days. He has to provide this financial statement with all transparency for estate valuation. Section 130 provides that the authority sends a notice and issue public notice inviting claims from creditors. Notice published in newspapers on premises and on the NCLT premises, on the notice board of the A, and also on the website of the A. The intent of this section is to ensure wide creditors' awareness and invitation for the claims. Here again is fresh claim to be filed by all the creditors to the bankrupt. Creditors must register claims with trustee within 7 days of public notice. As the time provided for the registration of the claim is 7 days by the trustee. Ensures all creditors' claims are officially recorded. Trustee prepares list of creditors within 14 days based on the application and claims. Establishes official creditors list for further proceedings. Trustee issues meeting notices within 21 days, including date, proxy forms, and voting instructions. Then once the list of creditors prepared by the trustee, then he has to issue a notice for the meeting of the creditors within 21 days, and the notice includes the date, time, place of the meeting, proxy forms, and voting instructions, everything. Then section 134 provides that the trustee convenes creditors meeting and decide quorum. Business includes committee formation, minutes recorded, then limited to 7 days. Here the 134 provides that the quorum is not prescribed by the law. Quorum is to be decided by the creditors themselves. Enables organized creditors decision making and record keeping. Voting rights assigned by RP. Creditors not on list on or associate disqualified. No vote on unliquidated debts. Trustee has to ensure fair and regulated voting process in the creditors meeting. Trustee administers and distributes estate as per chapter 5. Trustee manages asset distribution according to the law. The trustee report to committee on completion. Committee approves report and may release trustee. Committee supervises trustee and approves closure of administration. Then there is a provision for discharge order in section 138. One provides that the bankruptcy trustee shall apply to the adjudicating authority for discharge order. Once the process is complete for the bankruptcy, then the trustee has to apply to the adjudicating authority for the discharge order. 138(1)(a) provides that after the expiry of 1 year from the bankruptcy commencement date, or within 7 days of the approval of the committee of creditors for the completion of administration under section 137, if this occurs before the 1 year period. The maximum period provides for this bankruptcy is 1 year. After the 1 year, the discharge order can be filed by the trustee. 138(2) provides that the A shall pass the discharge order upon application by the bankruptcy trustee under subsection 1. 138(3) provides that the copy of the discharge order must be sent to the board for recording and entry in the register under section 196. Effect exception and section 139 effect for discharge. Section 139 provides for the effect of discharge. 139 discharge order under section 132 releases the bankrupt from all the bankruptcy debts. It does not affect the functions of the bankruptcy trustee. And it also does not affect the operation of chapter 4 and 5 of part 3rd of the code. It does not release the bankrupt from the debts due to fraud or breach of trust. Does not discharge the bankrupt from any excluded debt as defined in the code. These are all about the bankruptcy in brief. Now we can discuss some case laws if you permit.
Yes, sir.
So this is important. Good case in the matter of the Central Bank of India versus Vinu Sagar. It is Kochi bench, OCLT Kochi bench. 95 one application filed, sir, and Mr. Vinu Sagar was a personal guarantor and default filed by the Central Bank of India. And this CD is the Jupiter Lease Private Limited. Now, sanctioned credit facilities in 2012, and accordingly, loan agreement was executed in 2012. And this loan was taken for setting up a new factory unit at Maharashtra. Here, the petitioner, which is the bank, which states the hypothecation agreement dated at 18 June 2012 was executed respectively against the sanctioned credit facility. And it was also stated the promoters of the company had executed the personal guarantee in favor of the bank, thereby assuring repayment of the credit facility in the event of default by the CD. And various legal action has been commenced by the financial creditor in the recoveries of debt and bankruptcy act and the SARFAISI. And one property of the CD was also sold in the auction conducted by the financial creditor. And thereafter, the CRP has been initiated against the corporate debtor, for which the personal guarantor has given the personal guarantee. And in 2023, December 23, and here the petitioner, which is the financial creditor, served a demand notice to the guarantor in prescribed form B, as we discussed. And demand notice in section, as per section 95(4)B, read with rule 7(1), which was the statutory notice issued by the financial creditor to the debtor in 2024. The petitioner also served a copy of petition to the personal guarantor as well as to the corporate debtor. Then the personal guarantor, even after receiving of this statutory notice of demand, has not failed to repay the amount. Then thereafter, the financial creditors initiated the proceedings under section 95 of the code before the timeline. The amount of default was more than 1 crore rupees, and it was this default amount, that amount also registered with the information utility, as we discussed in the seminar, that if the debt is registered with the information utility, then the debtors cannot dispute the debt. RP was appointed here in the PRP process, and he has filed his report in section 99, recommending the admission of the company petition. Against this application filed for the admission of the company petition, this PRP, initiation of the PRP process against the personal guarantor has filed their reply stating that the petition is not maintainable and premature at this stage, as the insolvency proceeding against the CD Jupiter Lease has already been admitted and are currently under consideration of this tribunal. The personal guarantee can only be invoked if the debt is not resolved through an approved resolution plan, or if the CD goes into liquidation. In this case, the RP has invited resolution plans with the last date of submission being 23rd December 24. And the respondent, who are the promoters of the corporate debtor only, intends to submit a plan that benefits all creditors. initiating separate insolvency proceedings against the personal guarantor now would lead to legal absurdity and duplicity of the claims of the same debt. If the debt is resolved through the resolution plan, such action would be unjust and cause undue hardship. Therefore, it has been requested that the report be kept on hold until the resolution process is completed. Therefore, it is requested by the applicant that the Section 9 report can be held on can be kept on hold until the resolution process is completed. It was also contended by the defendant here, the personal guarantor, that this application filed under Section 95 is barred by limitation at the federal law that no action can be maintained against a personal guarantor for a time-barred debt. The invocation of the personal guarantee in this case is also legally untenable and hit by the law of limitation. It has also been contended that the many proceedings has been initiated by the financial creditors in the RTE and SARFAISI Act, and they also had sold some properties of the corporate debtor. And when the CRP process is on, and they should wait for the result of the CRP process. This financial finance facility provided by the bank declared NP on January 2015 due to delayed repayment beyond the CD control. It is also contained by the petitioner that this personal guarantor as per petitioner own case, the date of default is 2014 when they declared the NPA. Therefore, the present proceeding against the personal guarantor are barred by the limitation. Accordingly, the RP report which fails to consider the fundamental issue is per se untenable and deserves no consideration. Both the sides was heard by the Honorable NCLT. Counsel of the personal guarantor also submitted that this application is premature as the assessment director personal guarantor of the MSME unit, that is the corporate debtor, has already submitted its resolution plan. The said resolution plan is favorable to all the creditors, and after deliberation, COC would forward that plan to this tribunal for approval. So the applicant, being the secured creditor in said pending CRP proceedings, has no right to initiate the present application. Simultaneously, proceeding against the personal guarantor not only unwarranted but would be harsh. It is further argued that the application has failed to prove a record of service of notice of invocation of the bank guarantee. As such, the application under Section 95 is not maintainable. He further submitted that the Annex 7 is a deed of hypothecation and not a deed of guarantee, because the RP in his report in Section 99 has mentioned about the deed of hypothecation, and he has not mentioned anything about the deed of guarantee. As such, the resolution professional committed a grave error in relying upon the same. It is further submitted that the claim against the principal borrower is barred by the limitation. As such, no proceedings against the guarantors can be invoked. It was argued by the personal guarantor that since the CRP has been initiated against the cooperator and one of the guarantor has submitted a resolution plan and the recovery made under such plan would satisfy the debt. As such, the applicant has no right to proceed against the personal guarantor. The proceeding under Section 7 of the IBC are not recovery proceedings and is settled proposition law. Even during the pendency of the CRP, the creditors has the right to invoke the personal guarantee and proceed against the directors under Section 95. It has been contended by the financial creditors that even during the pendency of the CRP, creditors have the right to invoke the personal guarantee and proceed against the directions under Section 95 of the IBC. And they rely upon some judgment, Paresh Rasogis versus Omkara Asset Reconstruction Private Limited. When it is held that even during the commencement of the CRP, the personal guarantee Section 95 application can be filed and the PRP can be initiated against the personal guarantor. So, in the light of the said judgment, even the personal guarantor, that is the suspended directors of the city, in his individual capacity, has filed the resolution plan that would not absolve guarantors from their liability in terms of guarantee agreement. So, on that account, we find that no merits in the arguments as advanced. So NCLT viewed that even though the CRP is on, Section 95 application can be filed against the personal guarantor. Further, it is argued that the bank has failed to place on record the proof of service of the demand notice. Bank has annexed a notice dated 30th March 2024 on record along with the report of the resolution professional at page 58. Postal receipt dated 30th March 24 and the tax report evidencing due delivery demand notice to the addressee can be considered as valid proof of service. Though the bank has not placed a postal receipt or tax report in their application file under Section 95. Taking advantage of the same, the respondent has come with a plea that it has not received any such notice. So they had not placed this receipt of the speed post and their tracking report. And taking advantage of the same, the respondent or the personal guarantor has come with a plea that it has not received any such notice. When the bank has produced such evidence of depositing and delivering before the RP, it shows the act and conduct of the respondent tribunal would come to the conclusion that the respondent have not come to the surrender with a clean hand. Applicant bank has proved on record the execution of the guarantee agreement. There is no denial of the execution of the guarantee agreement. So here the bank financial creditors of the applicant mentions that there is no denial by the personal guarantor that he has not executed any personal guarantee agreement. Personal guarantee agreement has been executed. That is the undisputed fact. And reliance on the hypothecation agreement by the RP cannot make this application under Section 95 illegal or not to be approved. Applicant bank also mentioned that they had initiated the SARFAESI action and they had issued the Section 13(2) application. Firstly, they had not mentioned about or enclosed the 13(2) notice issued to the personal guarantor. On the strength of the tribunal, they had enclosed or they submitted the notice issued under Section 13(2) of the SARFAESI. Issued to Mr. Vijayan Thopil Vidyasagar with copy to Mr. Vinu Sagar. Vinu Sagar here is the personal guarantor. So it was issued in favor of Mr. Vijay Thopil and it only CC to Vinu Sagar or not addressed to Vinu Sagar separately. The copy of said notice was forwarded to 3 persons, including the present respondent, without any request to repay the said amount, without any recital about the invocation of the guarantee. The layout of the demand notice issued under Section 32 of the SARFAESI is represented below under that mention about the 13(2) notice issued. Bank has just forwarded the demand notice to the respondent without disclosing any purpose, object, or reasons for forwarding said notice to the respondent. Notice issued under Section 32 of the SARFAESI can be considered as valid demand and invocation of the bank guarantee, but there should be a specific averment in this notice, and the notice should be addressed to the guarantor with a clear intention to invoke the bank guarantee. Notice issued to third party. Notice issued to third party with the intention to invoke the guarantee against the adhesive only, the copy thereof forwarded to the respondent would not constitute a valid demand and invocation of the guarantee as required under the law. There is no provision to draw conclusion on implied meaning. In the it also led on the Honorable Anklet matter in Asha Banstilal Surana versus State Bank of India, where it says that the demand notice issued under Section 13(2) of the SURFICE sent to the guarantor would be a valid notice for the purpose of invocation of guarantee. But this, in this case, has quite distinguishable fact as in the present case. A copy of demand notice was sent to the guarantor respondent herein, but there was no demand or invocation of the guarantee. Though in the said notice, the bank invoked the guarantee and raised the demand from one of the guarantors, such demand and invocation of guarantee cannot be used against the respondent as liability of all the guarantors and borrowers. Though it is joint several coextension with each other, it is prerogative of the bank to proceed against the borrower or guarantor against one of the guarantors. So individual notice of the demand and invocation of the guarantee is very much required to enforce the terms of the guarantee and agreement against the guarantors. Simpliciter forwarding copy of the demand notice addressed to some third party without raising any demand from the respondent in the demand notice issued under Section 13(2) of the SURFICE would not constitute a valid demand and invocation of guarantee. So no limitation will start against the respondent from the demand notice issued under Section 13(2) of the SURFICE. The bank has filed one application under Section 7 against the corporate debtor, and this article by all this has recorded the following findings. Even in the present case, the statutory demand notice in Form B was issued on 30th March 2024, and prior to that, there was a balance confirmation in the balance sheet in 2023. And then light that there is many judgment of Supreme Court which says that if there is acknowledgement of the balance sheet, it should be considered as the limitation, and the limitation will start from there. So there is no this application within limitation as per this order. Bank has not issued any demand notice invoking guarantee for the respondent except the notice in Form B. So the question would be whether in the absence of any formal demand notice and invocation of bank guarantee notice issued on Form B under Rule 71 of the PRP regulations, rules would constitute valid invocation of the guarantee or not. Then they also relied on the State Bank of India versus Deepak Kumar Singhania by the judgment made by the NCLAT, when it is provided that the personal guarantor liabilities arises only after the invocation of the guarantee as well as deed of guarantee. A demand notice under Rule 7(1) is a statutory step, not an invocation of the guarantee. And both conditions under Rule 3(1)(e) must be fulfilled for the guarantee to be liable, guarantor to be liable. So, invocation of guarantee is must for initiation of the PRP. Bank forwarded the copy demand notice issued as 13(2) of the SURFICE to the respondent. There was no demand from the respondent, so that was not valid invocation of the guarantee against the respondent. Statutory notice issued in Form B under Rule 71 of the PRP regulations. Rules cannot be considered as valid invocation of guarantee, makes this case premature and not maintained for the purpose of Section 95 of IBC. In the light of 4B analysis finding, we find no merit for the admission of this petition for Section 95 of the Code, and the CPIBC this dismissed. This is the case that the invocation of the personal guarantees must before the filing of the application under Section 94 or 95. So, sir, now we can take any question answer if anyone has any queries. Otherwise, we can end the session here.
Sir, one question.
Yes, sir.
Suppose in case of Section 7, 8, 9 application, registrar verifies whether it falls under the limitation or not. Am I
Yes,
right?
sir.
Whereas in
Registrar.
case of 95, it is based on the recommendation of the internal resolution professional. Based on the recommendation only, NCLT admits the application. So now the question is whether RP has to ensure that application is falling within the limitation or not. Am I right?
Correct, sir. Right, sir. In the Section 99 report, the RP has to file with the NCLT. He has to see that this application is within limitation, and he has to mention specifically that this
Categorical,
application is under limitation, and this can be allowed by the NCLT. So here this is a duty of the RP to see that this application within the limitation. He can only recommend finally the and honorable NCLT has to take the decision whether the limitation is there or not.
Hmm.
It can, if the
No.
RP says that it
So
is
he's
not
only facilitator. He has to facilitate
Yes.
saying that it is within the limitation based on the following facts. Like that, he
Yes.
has to mention in the memo or what?
Yes. Correct, sir. Correct. He's only a facilitator. Otherwise, the final decision has to be taken by the NCLT.
NCLT. So, but the bonus is to ensure that it is within the limitation.
Yes, sir. Yes, sir. Sir, any more question?
But still, that question is doubtful whether it has to be, filed before NCLT or DRT. There are some cases which are filed.
We can discuss, sir. Which case, sir?
No, I'll tell you, sir. I have taken one. There are some 3-4 cases pending before what you call DRTs in case of PG to CD, I think, sir. Just give me a minute.
Yes, yes, of course.
But the source of this information is ChatGPT. State Bank of India versus Anil Dhirubhai Ambani, it is a DRT Mumbai, Section 95 of IBC.
Okay.
And IDBI Bank versus Kapil Vadvan, DRT Mumbai. PG insolvency initiated against Kapil Vadvan. Again, Bank of Baroda versus Sanjay Singhal, Bhushan Steel. I think it is also PG, that is before DRT Delhi. I think they might have transferred later on all these cases to the where the CD is undergoing this year. Yeah. Under Union Bank of India versus Ravi Parthasarathi, DRT Chennai.
Yes. Now I think that now correct.
So the jurisdiction question is, I think, issues are there, I think.
He can only recommend, sir. RP can only recommend. Otherwise, finally,
Hmm.
the NCLT has to decide whether.
Okay. Okay, sir, fine.
So, if Anjali ma'am is here, we can conclude the session. Anjali ma'am, you are here?
So I'm
Hello. Yes, ma'am.
now.
You are not audible. I think, sir, we can now conclude the session. Thank you very much all for joining here.
Yes, sir, I think you must be sharing this PPT to
Yeah.
ICASI.
Yes, I will be sharing to ICCIP and they will
Okay.
share with you.
Okay, sir. Thank you.
I think Anjali ma'am is not here, so we can conclude. the
I
session.
think her voice is not clear.
My voice is not clear, sir?
No, madam's voice is not clear. She's speaking something, but breaks are there.
Okay.
Now I
Okay.
think I'm not able to. We are leaving,
So,
sir, then.
Okay, sir. Thank you very much for joining, sir. Thank you very much.
Thank
Thank you. हेलो क्या चीज नहीं हाँ आप कर लो एक बार खत्म करते फिर इसको